Hello everyone, I'm Dwight Mitchell, the founder of the 501c3 nonprofit Family Preservation Foundation and the parental rights groups Stop CPS from Legally Kidnapping Children. We are now over 11,000 members strong, and over 21,000 people have signed our petition on the website change.org. Yay! Today I wanted to briefly provide you with an update on our federal case. Recently we received the final determination from the 8th Circuit Court of Appeals. I say finally because when we received the opinion of the 3-judge panel who ruled on our case, we were flabbergasted. And we motioned the court for an en banc review panel by all 13 of the sitting judges on the appellate bench of the 8th Circuit, because we wanted the whole bench to review our case because we just thought that opinion was hogwash. Our arguments were so compelling and the physical documented evidence against the county was so strong that after argument where the 3-judge panel was hammering the county defense attorneys with question after question after question, we were 100% confident that the 8th Circuit Court of Appeals would overturn the lower court's opinion and send it back down to the district court for a full trial. Boy, were we wrong. Before I get into the details of the court opinion, I got to vent a little because I'm very upset about the entire Minnesota legal system. I'm sure you are too, because we've all been fighting together, so you know what I'm talking about. You know, the George Floyd matter shows something is wrong in Minnesota, and it's just not the police. You know it, and I know it. Minnesota's Child Protection Services and the judges unconstitutionally violate human rights too. It's not an accident in this case that I also happen to be black. And everybody knows I don't pull the race card. You've known me for years. I never bring up race. And while I know CPS takes children of every color and nationality, everyone in our parental right group knows that I'm fighting CPS for everyone, and I've been doing that for years. But the fact of the matter still remains that in Minnesota, compared to Caucasians, CPS removes approximately 5 times more children of African American descent from their homes than Caucasians. To make matters worse, this disproportionality has been stated as a problem in every annual Minnesota out-of-home placement report to the governor for the last 10 years, yet little has been done to make this racial disparity better, or even decrease it a little. You know, come on, enough is enough. You know, I'm slowly coming to believe that there is no such thing as justice in Minnesota, or even in America for that matter. I'm not naive. I'm 59 years old. But I do feel all government officials have a secondary agenda, and all should be limited to an 8-year maximum limit in office, just like the president. Okay. Enough of my venting. Let me get back to the case. It's one of those things that popped into my head that I just had to get off my case. So the panel decision decided to avoid rather than adjudicate our constitutional claims as Minnesota CPS statutes chilling parental rights. In fact, we were completely denied meaningful judicial review. We filed a 141-page federal complaint against 14 county defendants and only received a 16-page appellate opinion that covered very little of our complaint at all. We were like, what? The panel's avoidance was clear and incorrect based upon the results of the errors in the 3 subject areas they did choose to speak about out of our 24 claims. First, the court should have applied strict scrutiny review to our constitutional claims against Minnesota statutes chilling parental rights instead of the shock the conscience test. We're like, what? Second, the court should have recognized our associational standing of our group, Stop CPS from Legally Kidnapping Children. especially if groups like the ACLU and NAACP can sue on behalf of its members. Third, the court should not have applied qualified immunity to Dakota County. We were suing the county. Counties are not entitled to qualified immunity by law. It should have went back. The panel's decision does not follow the U.S. Supreme Court's jurisprudence on parental rights, and that government interference when parental rights is subject to strict scrutiny under the Traxel case law and its predecessors, which deal with CPS cases. Instead, the Eighth Circuit rejected strict scrutiny under Traxel, even though Traxel was decided by the Supreme Court in 2000, and used a case from 1998 with the County of Sacramento, which mandated the shock the conscience test for damages against police, which makes it even harder to file a federal lawsuit against police officers. I'm like, you're talking apples and oranges. So, as it stands, a split exists between the U.S. Supreme Court and the Court of Appeals on whether claims against child protection services should be governed by the U.S. Supreme Court's strict scrutiny test of Traxel and its predecessors, or the shock to conscience test of the County of Sacramento dealing with police officers. You know, we were sitting there going like, wow, this panel's decision leaves us with no path for any Minnesota parents or association to sue under 42 U.S.C. 1983 against unconstitutional CPS statutes and CPS misconduct. With this ruling, we're left with no other choice other than to appeal to the Supreme Court of the United States. You know, on the good side, our strongest argument for the U.S. Supreme Court granting the petition is that the Court of Appeals have abandoned Traxel, which they decided in 2000, which deals with strict scrutiny analysis in child protection cases. Everybody has done that except for the Sixth Circuit. Just recently, the Sixth Circuit on March 30th, 2020, a couple months ago, in Skolkers versus Kramer decision, applied Traxel strict scrutiny in their child protection case like they should have. Of course, we agree with the Sixth Circuit, and that was our argument also to the Eighth Circuit, which completely ignored us. So the circuits are split on the best circumstances for, circuit split are the best circumstances for the U.S. Supreme Court to grant a petition to hear our case. So we have a shot at the U.S. Supreme Court taking the case and reconsidering its parental rights decisions and applying them to protect ordinary parental rights from child protection services interference, since the last time they discussed this was in 2000, which was about 20 years ago. There really is too much detail for me to get into. You know, all of the court filings, the appeals, the opinions can be found on our website, familypreservationfoundation.org. Just look under the menu subheading for legal case. I'm laying all that out right now. It should be out like today or tomorrow. We are currently working on our appeal to the Supreme Court and have about 90 days to get that filed. That's due in the middle of October. So stay tuned for another update, which should be coming to you soon, as there will be ways for you to help. Petitioning the Supreme Court is very expensive, and I will need the help of our team and our community. To be honest, I plan to set up a fundraiser to assist with the legal fees in order for our case to move forward to the Supreme Court. As everyone knows, to date, I personally have paid all of the legal fees myself, which has spanned years right now. And I'm going to need your help to move forward. Hopefully, I hope you agree with this very important case and support our petition to the Supreme Court of the United States. Please read our documents and what's out there. Our petition, our draft petition to the Supreme Court will be out in a couple of days. Finally, in closing, please remember to view our free online video library and handouts to answer all of your questions for CPS and how to work with your attorney and what should be done with your public defenders. we've all been victims of CPS and their unconstitutional practices, and this video library it will be a benefit to you. There's a lot of knowledge, and it's a great help for everyone. Thank you very much for all your support thus far. It's been years, and all the best. I'll see you soon with another update. Thank you.